mode.
Hi, everyone. Thank you so much for joining us. This is Judy Jordan. I have the opportunity of being the moderator for today's panel. We have over 300 people registered and participating in the webinar, so we thank all of you for being online with us today. Our participants are from academia, government, and industry, and the majority are from academia. As you remember, today's webinar is all about intellectual property, and we know that the basis for most ventures today are really discoveries in science and engineering that are based on their inventions, and that means their intellectual property. So we're all about talking about the role of tech transfer and protecting and commercializing university intellectual property. How does intellectual property law help us? And what are the roles of students, postdocs, professors in the process? We're also going to talk a little bit about the differences or not about protecting materials versus other types of inventions, mostly university-based, and how does that actually look? This CSMC Innovation and Innovators ongoing webinar series will be going for the next 5 years. We'll have at least 3 a year, and here are some example webinars. Please do visit us on either of those two web pages to learn more about the webinars. We're very excited today to have on the webinar Mr. Stacy Slater of Clark-Quist-Sparkman and Dr. Mary Foley-Phillips of OSU. Let me take a moment and introduce our two speakers before we get started. Mr. Slater joined Clark-Quist-Sparkman in 1990 and practices all aspects of intellectual property law, patent, trademark, copyright law, with primary experience in patent prosecution and chemical and biotechnology and mechanical technologies. He's in foreign applications as well as related matters to pharmaceuticals, drug deliveries, and vaccines. He received his law degree from the University of Oregon School of Law, and he is a card-carrying scientist in organic chemistry from Oregon State University and a bachelor's degree from the University of Colorado. Dr. Mary Foley-Phillips is Associate Director for the Office of Commercialization and Corporate Development at Oregon State University, and as such is responsible for the management of intellectual property of OSU inventions. Prior to that, Mary had intellectual property and technology transfer experience at the Oregon Health and Science University, and she currently serves on the board for the Corvallis Business Enterprise Center, showing exactly the link that universities have more and more with the wonderful world of economic development. She has a PhD in physical chemistry from the University of London's Imperial College of Science, Technology, and Medicine, and has done a postdoctoral degree at the University of Oregon, and it's due that in working for the development of novel that sparked her real passion, the idea and importance of patents, intellectual property, and how that links to the process of commercialization. I won't bore you with my background. I'm all about commercialization of technology, and I'm currently a partner at ecosVC, which is a venture development and investment firm. Let's kind of set the context for this webinar today. As probably all of you are aware, intellectual property is a very, very important field, but it is of a broader area called intangible assets, which will be the subject of other webinars during our series. But basically, intangible assets are any items that lack physical substance, but do provide long-term benefits to the company. As I mentioned, intellectual property is a subset of that. Many of those pieces of intellectual property, patents, copyrights, trademarks, trade names, are things that you can actually see. They're intangible because they're not exactly bricks and mortar. They're not exactly something that you actually can see and touch and feel. Certainly, trade secrets are something that isn't even something you can read. That's something that everyone wants to keep very, very secret because that's usually the heart and soul of a lot of processes. Intangible assets, however, also include things like franchise licenses, government licenses, goodwill, and the most important piece, at least according to recent data going forward for intangible assets, is your reputation. Basically, according to the Intangible Asset Finance Society, intangible asset values represent more than half of the value of the median publicly traded company. We've all seen some very unfortunate situations from major corporations where, because of process breakdowns or situations with suppliers, their brand has been unfortunately harmed, and they've seen stock depreciation, loss of employment, things like that. And this reputation risk is really very serious. As indeed, according to the Intangible Asset Finance Society, you can see in the little diagram that there's quite a large number of Standard & Poor's index companies that disclose this sort of risk, and that this is really an important issue. As we said, that's for the future, but for right now, we're talking about intellectual property tech transfer in you. Our format is really easy. First of all, we're going to ask each of our panelists 2 broad-based questions and ask them to respond. Then we're going to open to Q&A from you. Because of the large number of participants, we can't allow you to actually just ask those questions on the telephone, but please, you have a question box. Please ask those questions anytime you would like. We are absolutely accumulating them the whole time, and during this Q&A session, we'll absolutely open it up to all of those questions. I will be posing those questions. Please don't be offended if I don't directly ask your question. Oftentimes, because there are similar questions, I aggregate them and ask it that way. And last but not least, we're going to ask for some free advice. We're going to ask each of our panelists to summarize and leave you with some words or wisdom. So I'm going to start with that one with Mary. Mary, I know that as a faculty member, oftentimes I believed, and I had the honor of being a faculty member for a while at some universities, and basically I thought and believed I could just come with any idea that I had and you would help me. You were there to serve basically only me. And yet on the other hand, I had this feeling that that's not quite what really happens. So could you help us with, from your perspective, what are like the most important roles of the Tech Transfer Office? Of course, including taking care of us as faculty.
Well, thank you, Judy, for inviting me and your questions, and everyone for inviting me to speak. The #1 role, really, of Tech Transfer Officers and ours connect the university with industry. That's what we do. We do that for the faculty and for the industry people we work with on the other side. And the important role there is that we bridge that gap between the 2 cultures of academia and industry. They have different perspectives and outlooks. Another part probably should explain about how academic tech transfer comes into play is that we are the creation, as it is today, the Dole Act, which was created in 1980, which gives us the right to own title to university inventions that come through from federal funding. Before that, the government used to own all inventions from federal funding. So our role actually now is to file the patent applications from federally funded inventions that have commercial potential and could be taken forward for an industry partner. And our other role, and as it relates to faculty, is very much a very important role of really explaining what our office does, why it's important, what the patent process is, how it will affect you. That goes for the students, the postdocs, and the faculty, and even the staff that we work with at the university. Do you need more?
Thank you very, very much. So the bottom line, really, you are actually not only to listen and help faculty and students, you're also there to make sure that you have all of those links pulled together with external industry. Is it a challenge when you think about the broad range of industries that you have to deal with to actually make those links and put them together?
Many people actually say tech transfer is a contact sport. It's a lot about creating the relationships. Trust is very important. I know many of our faculty here have relationships with industrial scientists, their counterparts there, but they don't actually have the relationships with the legal departments or the people who make decisions about signing a license agreement. So we create those relationships and the understanding of language between the 2 parties, between the university and industry, and the motivations of why they would be interested in the intellectual property. And it's a different culture. We use patents here really as basically lures for industry. It's something that will be of use to them, and we're using that to entice them to come to the university, take notice of what we're doing. Industry generally tends to use a lot of their patents as weapons and to defend themselves. Yep. So it's a very different motivation from the 2 sides as to why we actually get involved in intellectual property.
Right.
together. So.
Thank you. Thank you. I'm going to move on now to a question to Stacy. Stacy, help us from the attorney's perspective, please. And I'm getting lots of questions in. So first of all, I want to acknowledge our participants and say thank you. I've got an enormous number of questions in. Interesting, they're all aggregated about a bunch of areas. So look forward to challenge, guys. I just want to warn you about that now. Stacy, when you think about being an IP attorney, what do you look to provide to an inventor? Other than the inventor comes in and the inventor thinks, now you're going to save them, you're going to figure out everything and just make it all happen. I have this feeling it isn't just writing that patent that you provide. What do you see as the services you want to be able to provide? And what should an inventor think about when they try to come to you? What are the types of questions they ought to be prepared to answer, to think about, because you actually provide some areas of IP?
Well, thanks, Judy. The first question I think an inventor needs to ask is whether or not to file a patent application at all, because patents are very expensive. Maintaining and obtaining a patent portfolio can be very expensive and can really eat at the bottom line of a small startup. Patents have limited terms, and you don't need a patent to practice. Many people think you need a patent to practice in an area, and you don't. So businesses might first think about whether or not to use trade secret or non-disclosure or non-use to protect their property. The second big issue is procedural issues. What is a patent? When do you file a patent? How much is it going to cost? Those kind of questions. But more importantly are more substantive issues, such as what is an invention? How do you define the invention? What is prior art? Particularly the own inventors own prior art. They're sometimes unaware of that kind of art. Who is an inventor, and therefore who is an owner? What kind of level of disclosure is required to support a claimed invention? And then there's some peripheral issues to business aspects, such as are there patents in the field that you need to be aware of, that you need to be, either license or be aware of so that you can avoid? Should you enforce your patents? Should you use them to develop to generate revenue, or should you license competitors or customers? So there's a lot of issues that we can try to help inventors with.
So it's around not only helping them figure out, if I can put them into some big buckets. One is it something that's patentable? What is how do you fit? What is your freedom to act? Another is, how do you actually maybe aggregate other technologies, other things that are going together, being aware of who else is out there and whether or not you should even patent it versus protect it in some other way. Am I hearing that kind of right in those big buckets?
That is correct. Those are the big buckets. Again, whether you should proceed at all, and if you do proceed, how do you proceed? The big issue is how do you define your invention. Sorry, Judy, go ahead.
Please.
Go ahead, Judy.
So a big way you're saying is how do you actually define your invention, and whether or not, from the way you're looking at it, that's really a definition of an invention.
That's correct. Patent attorneys tend to think of inventions more expansively than most inventors. For example, an inventor might come to us with a drug that has a halogen, a fluorine atom in a particular position. We think of that immediately not as a fluorine but as a halogen. To think much more expansively about inventions than do the inventors. We can help define what that invention is, then look to the prior art to see what level of or scope of protection we can obtain for that invention.
Interesting. Interesting. So that's a big part of what people don't really, I think, fully get, is that there are prior arts, and having some information about that might not hurt. That's actually, I'm going to go back to you, Mary, exactly the series of questions we want to ask you next, which is when faculty members or students come to you, and we're having a whole bunch of questions about that sort of stuff. When they come to you, what should they prepare and bring to you to help facilitate a process of you understanding the value of what they've created, and what should they maybe be prepared not to have done or disclosed? Could you help us with some of those, the big, clear, crisp buckets of items they should actually bring to you, that you move more quickly to helping them figure out, is it patentable, all the things Stacy said, and how you could link it to industry?
Typically, inventors, students, faculty often actually prepare a whole list of questions for me. Really is the biggest thing, and it's through the questions you can actually often get at the heart of the invention and what's needed. One of the question we have to ask a lot when we get an invention disclosure, or it might be a pre-invention disclosure when I'm talking to folks on campus about their research, is when they're going to publish. And that information, do they have a manuscript ready, prepared to go to the publishers? Have they got a poster up in the corridor where they're showing their invention? Because that's, and teach them that that's actually a public disclosure. You know, have they taken at any seminars? That's the first kind of information I first of all need to obtain from them, because if they've already published it, or it's been up in a poster, or they've talked about it, it's a public disclosure, and it can be a bar to patentability. And if it's been more than a year, then there's no way I can patent that or file for patent protection around that invention. So that's the first part that's very important. We also have questions about where they got their funding from. You know, whether it's federal funding, or it was money that came from a gift, which is fine, or it's money that they had, funding that they had from industry-sponsored research agreements. And so that helps us do a lot of diligence on our end when we first receive an invention disclosure, to go through, first of all, to see if we can file a patent first, then to see if we have any obligations to any of the funding agencies regarding what we can do next if there is an invention, as that works through. And there's also questions on that as well, about, you know, who owns the intellectual property they've created, whether they're OSU employees or they might be courtesy faculty. It might be an undergraduate student involved and they don't have an obligation to assign ownership of their intellectual property to the university. There's a whole series of questions that we ask, ask them to have prepared. I also ask them to explain really what their invention is. It's rarely that we are domain experts in this office in every area of technology, and we don't always understand initially what the invention is or why it's important. And so we rely heavily on the faculty and the students to really kind of help us understand why their invention might be significant and why it's useful. So
let me ask you a question in a that's great. Let me ask you a question in a slightly different way. If a faculty member or a student believes they have something that might be of value, you've brought up so many important issues. Gosh, you know, you talk to people in the corridor, you put a poster together because you're talking to people in your research group, you chat with people down the corridor. If people think that it is something that could create a body of intellectual property, should they chat with you on, or should they, no, there are classes, seminars that universities provide to kind of help people get that basis up front, because you would be deluged if everybody came to you with that question?
Oh, there's the deluge part that scares me. That's I would rather know in advance. Especially if it's going to be important. Relationships with a number of faculty I have on campus, I've been tracking their research for years. They can ping me an email, ask me, you know, put NDAs together, actually the non-disclosure agreements or confidentiality agreements if they want to go talk to somebody. It's not really a deluge. It's something that is it's a conversation, and it's part and parcel of the role that we play within the university to help triage all those questions. And it's really important and vital that we get in early to give them the answer, because the last thing I ever want to do is hold up somebody's publication.
Right. No, absolutely. Absolutely. So the earlier you know, if you have any questions, ask you, and I'm getting a whole series of questions on that. So I'm going to move on to Stacy so we can start getting to our little lightning round questions here, because we're getting a lot of great, really complex questions actually too from the participants. That was my warning, participants, to our speakers, that some complex questions are out there on the horizons here. They're excellent questions. So Stacy, kind of the same quick, if you could just do this kind of quickly, the important points that people should prepare to bring to you as an inventor to help facilitate the process from your standpoint. You know, we like to think that you are all free and you don't charge us because you're just Mr. Wonderful, but sometimes you guys actually charge And so to actually do this more cost effectively, what are some of the stuff that should be brought to you and what should have been done beforehand to make it easier?
Well, first off, we are wonderful, but we do have to make a living, so we do charge for our services. So one of the first things, as Mary was alluding to, is be aware of the prior art, and that might be your own prior art. Posters and oral presentations are prior art for countries outside the United States, and they can be in the United States too if it's more than a year. So the first thing is prior art. And I'm continually amazed that most people do not use the United States Patent and Trademark Office, their search facilities, and there's a wealth of information there. The second thing, as I was alluding to earlier, is inventors should think expansively about their invention and discuss with counsel what that invention is. Don't think of it, again, as a fluorine atom. It's a halogenated atom. So it's a halogenated derivative. So, and think not of your patent attorney as an adversary, but somebody you can actually talk to and who will help you define some of the of what you're trying to achieve. Another mundane aspect of what we do is we write, and so if you can provide us an electronic version of, for example, a proposal, a grant proposal, a pre-publication, that's always very helpful so that we don't have to start from scratch. Another thing that we've talked about before is maintaining records, such as laboratory notebooks. And those laboratory notebooks need to provide enough detail for us to discern the invention. Again, a thing that Mary was talking about is the invention. We need to know it as well as the inventors, and we are science trained, and so they should feel free to talk to us, and they need to educate us as to what that invention is. So those are some of the main things that we try to do.
That's really great. That's really great. And I'm going to pick up on some of those things too, as a matter of fact. So Stacy, I'm going to start with you. One of the first questions we got, and I got a bunch of these, people are hearing about the new patent law. What is the new patent law? How does the new patent law interact with them, affect them? And is this actually going to change the environment or practice of how university technology transfer works, what you can patent, what you not patent, timing, etc. So Stacy, I'm going to ask you, participants, here's how we're going to do this. I'm going to try to go through a lightning round because I've got a lot of questions here, and I'm going to give it to one of the speakers. If the other speaker has something they really wish to answer and add in, please, by all means, say, I want to add something to it. That's great. But I'm going to try to get to as many of these questions as possible. So Stacy, could you help us with this new patent law change, the environment and practice of university tech transfer, how they would interact with you, and what faculty and students should think about?
Yeah, the new America Invents Act is going to come into being in sections. And so we are operating now under the current law, not the new law. It does not come into being in full until 2013. But it will change how our process. For example, we are going to a first-to-file country. That brings us into conformity with the rest of the world. And so there is some need to be more aware of getting to the patent office early, and it changes the definition of prior art so that public disclosures become more problematic for inventors. We used to have a year's grace period in the United States for certain events. We still will have a year's grace period for inventors' own activities. Other activities, there will be no grace period. That means we'll be an absolute novelty country. Most countries in the world are absolute novelty, which simply means that once an invention is in the public, it can no longer be the subject of a patent application. So there will be a need to proceed more quickly to the patent office in the future under the American Invents Act.
You know, that's a very interesting challenge, though, and I'd like to ask you just to kind of follow up that just for a second. In an academic situation, oftentimes we want, because that's part of what the world is all about, and then there's the patenting. Publications often take a heck of a long time these days. Patents take a heck of a long time. Could you, kind of in a lightning round answer there, we've got a bunch of questions around that. How do you balance those two pieces, and what would you suggest as an attorney?
Well, the first thing you can do is file what's called a provisional application. A provisional application is not necessarily as fully developed as a real application. So, for example, if an academic is preparing a publication, we can relatively early in the process, that frees that academic to go out and discuss the subject matter of that provisional application. So you can file a series of provisional applications and then preclude that from becoming prior art as you go out into the public and discuss it or do posters. So there are ways where we can facilitate your ability to publish and not abrogate your patent rights.
That was really helpful. I think people always feel it's an either or, the cup full or half empty, and what you're saying is no, 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 no. You can really kind of have your cake and eat it too in this. All you have to know is what the rules are. I'm going to bring this one over next to Mary, if you don't mind. I've got a series of questions here, and I'm going to try to aggregate this for you, Mary, in some way, and I might have to ask it in 2 or 3 ways. But it's all about determining inventorship. So here's a series of questions, and I'm going to kind of give you some of the pieces I'm getting. What you have, of course, you have students, you often have postdocs. The types of questions around this are, how do you determine invention and inventorship? So if you have a series of students working on something and there's a faculty member, the faculty member believes they're involved, but perhaps the students do not. How does that definition of inventorship get pulled together? How do you discover, if I may use that word, who are the right inventors, and how does the difference and does it matter about inventorship and who approaches you? Meaning, is it a student can come to you, faculty only, and how do you negotiate the differences between the faculty, the student, maybe even a number of students who are involved in that?
Thank you, Judy. Inventorship under patent law is pretty well defined. You don't become an inventor on a patent out of courtesy or because you like somebody. You have to have inventorship right. It's easily to correct as you go along. It changes sometimes in patent prosecution, but you have to have it right. So we actually ask a number of questions, partly on the invention disclosure, about who was involved, ask questions not only who are the inventors, how they got the idea, when they got the idea. Books help tremendously with that. So we ask a number of questions. At our level within the university, we rely initially on trust that the inventors know that they're inventors, but also recognize that in the publication culture, you know, it's quite common to put your PI on your manuscript, but it doesn't, just because you have a PI's name on a manuscript doesn't mean that they necessarily become inventor on the patent. So we actually go through a series of questions about asking, you know, how did you get the idea? How did you enable the idea? You know, what was involved? Whose idea? And that will often flush out who the inventors are quite early on. When there's a dispute about inventorship, I just give it to Stacy.
That's always an interesting way to do it.
But,
you know, so let me ask. Oh, sorry.
But what people don't always remember is the inventorship on a patent or patent application goes with the claims of the invention. So it has to be the claims, and it's not sort of all the background methods research that was done that describes how you might have got the invention necessarily. It goes with what the claimed invention is.
So if I can just see if I got this right. So for example, many times you're a graduate student and your PI or your advisor who got the grant, they brought the money in, they obviously had the idea for the work. If not, the grant wouldn't have been written. They wouldn't have been successful in getting the grant. You're now somebody in the lab doing the work. Could be a series of graduate students. And you mentioned it might not always be the PI. So basically, it's really working with your tech transfer office in clearly articulating who did the work, who reduced it to practice. Could you kind of expand on that a little bit, please? Not too long, kind of do it in a lightning round, but if you could help with that.
As a quick example, you know, you might write a grant proposal to propose that bubble gum is a cure for cancer and get funding for it. That's totally, you know, as an example. But that doesn't actually teach you how you would use bubble gum to cure cancer. It would take maybe somebody in the lab understanding the components, how you would actually give that kind of drug. I'm using a facetious example on purpose, but it would actually take understanding how you would use a material like that to cure cancer. And it's in that process of really understanding and being able to teach how you would use that you come up with the invention. But just by putting out an idea that something will work is not an invention.
Very interesting. I think that's going to help a lot of people. At least I really do hope so. So that's really something that people are very concerned about right now. And if I could actually kind of moving over to the Stacy side on another type of question, and then I'm going to come back to you, Mary, on another one. If you're someone who has a good idea and you put in any sort of a patent application or a provisional as you described, how important and how far does one have to complete it to reduction to practice? Because this sort of fits in with what Mary was saying. It's not just an idea. Oh my God. Server hasn't severed. Has been lost. Please check my network connection. Hi, everybody. Hello, everyone. I'm so sorry that we kind of flaked out there. It seemed to be something with our internet connection. Stacy and Mary, are you still with me?
I'm still here.
Brilliant.
Yes,
Stacy, fantastic. So, Stacy, I'm going to go back to the question I was asking you, but then unfortunately I got a bit cut off here. If someone wanted to, I don't know how much you heard, but what I was asking is, people are concerned about this idea of reduction to practice, not just who actually had the idea and then would be in the lab reducing it to practice, but how far does someone have to take something to reduce it to practice in order to actually patent it or have the patent granted, I mean a provisional or whatever. Could you kind of comment on the level of work that needs to be done in the whole process?
Yeah, first off, there is no requirement that there be an actual reduction in practice. An actual reduction in practice is I actually did something and I have a tangible result. A patent application is a constructive reduction to practice. If I can teach a person how to make and use the invention in the application sufficiently that they can go actually make the invention, then there does not need to be an actual reduction to practice. That can be different in the biotech arts. In the biotech arts, the patent offices are a little bit more difficult, particularly, for example, in the cancer area, wherein you might need to actually prove the ability to ameliorate or obviate a cancer. So it depends on the field, but in general the law is you do not need to reduce to practice. A constructive reduction to practice, i.e. a patent application, filing is sufficient.
Very interesting. So everybody, if you, the people out there have been asking, who've asked that question, I actually have a number of them around that area. When you say you don't have to reduce it to practice, do you mean that anything they've put in for a provisional patent would be sufficient? Or do they have to do something further along the way in the lab to prove that it works? They obviously don't have to get it fully to a product. And so some people have said, do I have to get fully to a product before I do that? No, I don't have to do that. But could you kind of give some examples about how far you got to go? And you thank you so much, and focus on the
Sure.
materials kind of thing?
Sure. So again, it's a constructive reduction in practice. The requirement in the patent law is that you teach how to make and use. And so I can have a mental conception of a composition of matter. And if I can, one, teach a person what that composition is, if I can teach teach that same level of skill how to make that composition, that's all that the patent office requires. It's helpful at times to actually have made it, but there's no requirement. You have to provide detail that will allow a person of any skill in the art to make it. Now, the problem comes in, though, when you get challenged as to that, and Mary and I have had some experience along those lines, where if you get challenged in a court, it is helpful to have an actual reduction of practice. But again, the requirement is you need to teach in words how to make the composition, how to use the composition, and that's all that's required in the patent law.
Stacy, can you help us define what reduction to practice means? I'll bet you that there's a bunch of people out there who are not quite clear on what those terms mean. Unfortunately, some of those of us who use these terms regularly, we don't quite always realize that people don't understand that. Might you help with that one, please?
A reduction in practice is simply I made it. I actually achieved that which I'm claiming now. It's a tangible result, whereas a constructive reduction to practice is a patent application filing that teaches how to make and use it, but I actually never did make that which is disclosed in the patent application.
So like I came up with an idea and I thought if I added A to B I would get C because prior art shows that A to B to C might do it, but I actually never went in the lab to actually make the compound, or I never actually commercialized the compound.
Never made it. So actual reduction in practice is making the material in this situation a composition. There is no requirement that you actually make the material.
And
Great.
that's where it touches in on my world a lot, Judy, because when I'm looking and talking to licensee or a startup company, they often are looking for that reduction to practice that we actually made it, often because they need to have that proof either to get funding or to take the technology further, that they've got some reduction in the risk that the invention will, they need it to know that it's going to work. So for patenting process, it's, as we go through, you know, we have a number of ideas, inventions that are patentable, but they might not be commercializable necessarily in the near future because it's not proven yet in tangible way that they actually will work the way that we have said that they will work.
That is an amazingly important point. Thank you so much for bringing that up. Stacy, you did a terrific job explaining what is required by patent law, but to actually take an idea and reduce it to practice is not only making it in the lab, but as Mary has just said, audience, it's also helping her demonstrate to the world that this is something that they really can care about. So it's not just, I thought I would add A to B, make C, and C would be the greatest new cure for cancer. Rather, it's how far along that path to demonstrating it's a cure for cancer have I gone, the value of that patent, the value to translating that to either a company as a license option or something to creating a startup makes a big difference.
But I will add with that another role of, you know, our office and what we do when we go out to industry, when we haven't got that reduction to practice piece, is to work with them so they will sponsor research back to the university into that lab to get that component so that they can get that extra data to show that it will work. So we collaborate with industry to bridge that gap between the fundamental research component and translate it into the commercializable component, and we do all that part as well within our office. So I just want to make sure it's clear too, just because you have a great idea and you can teach it but you haven't done it, doesn't stop people coming to talk to us about their ideas, because with their ideas I actually have a great opportunity to connect with the industry folks and reach out to try and attract funding to actually get that taken further if it's a great idea.
That's very, very helpful. So obviously don't just not come to you even if you haven't reduced it to practice. Perhaps you can get some funding for moving that forward for the lab. I'm going to ask you a slightly different version of that question that I'm getting a series about. So people are noticing here, of course, that in today's modern world, it's no longer that just federal funding agencies or state funding agencies are the ones that are providing funding for university research. Oftentimes corporations do that. So it's not just you've got an idea, if I may use these terms, you're pushing your technology from an academic lab and seeing whether or not a commercial opportunity is valuable. But sometimes the market tries to pull you in. Corporations might approach either a new startup or approach a lab to do some work with them. Could you help describe what the process should be, and what are there terms involved, or what should people be aware of, or how do they actually understand how they should interact with a company, and the role of the tech transfer office in both scenarios? One, when they simply are being approached by a corporation or trying to work with a corporation to do research funding, and B, if they actually have a startup through a university already or a licensable technology and they're being approached but not necessarily through you.
Ooh, well, to do the first one for when it's into industry-funded research,
Yep.
into the university, We handle many of those agreements as they come through. And it's pretty standard on the terms as an industry standard. Companies will fund research. We will complete the project. If there is intellectual property, the university gives the industry company an option to take a license to the resulting IP. And they get a first option to take a license to that. Very collaborative. I really enjoy industry-sponsored research because you have a really good partnership and you're both working with aligned goals to actually developing something that's going to be useful. So that's pretty straightforward. When it's with a startup company, there is a certain component that we have to work with on our research integrity side just to make sure that there are clear guidelines about research that might be happening in the lab of that particular faculty member and what he's doing with his company. And primarily what we look for, first of all, is to make sure that the students that might be working in the lab are protected so that they're not being asked to work 24/7 on a project that's going to be good for the company. So we do a fair amount of, not technically in tech transfer, but with our research integrity group to actually make sure that there's an appropriate management plan put together for those kinds of situations. But we have a number of, we handle all the SBIR allocation of rights agreements that come through, help to facilitate and make that happen. And, a big part of our job here is basically threading the needle on all those agreements and making it work.
So I think the audience really should hear everything that Dr. Phillips just said. Bottom line is, if you're being approached by companies and you're chatting with companies, do get involved. Get your sponsored research office, get your tech transfer office. Different universities call them different things, obviously. Get them involved in this discussion. There are procedures and processes, and nobody's asking you to reinvent a wheel here. And indeed, some of the discussions you may be having will be just problematic later on. So that's really a very, very important point to it. And I'd like to kind of ask kind of the question in a slightly, just one other piece here, and then I have a bunch of questions for Stacy. A bunch of concerns are, so if in this process, industry provides the dollars,
yeah,
does that mean they own the patent?
No, because we are a educational and research not-for-profit organization, institution. We are not contract research. So, and that's often one of the biggest bones of contention, working with industry who have been told that they will own all the patents, because it's something that we are not permitted to assign ownership of the inventions automatically to companies. And it's to do with our not-for-profit status. It also has to do with the funding for facilities at the university. We have a lot of tax-free bond dollars, so that would be considered a private activity, creates problems. And it's also somewhat antithetical to what we do as academics, as university. We do research. We don't do work for hire necessarily. We're doing research. So it's
just because they paid, that doesn't mean they get the patent itself.
Yeah. But the important, as I said earlier, it's about relationship building and trust. So it's very important that our industry partners, they get the reports from the research as it goes along. It's very important that we know if an invention has come out of that research, that we communicate back with them and let them know, because we want to see, all our goals is to see the research, what comes out of that, the inventions be successful to actually go into public benefit. And so we're all working for the same goal.
Absolutely. I'm going to move on because I have a whole bunch of other questions here, please. I'm kind of trying to get you to get through these questions as quickly as possible. So, Stacy, I think what Mary just said, she used the word assignment. This is really a critical issue that I think people don't fully understand the difference. I can be an inventor, but because I invented something, so I worked in corporate America for years. When I invented something, that invention was not assigned to me. and then necessarily the terms for which I gave over my assignment. In my case, it was $1 and a dinner. In some cases, it was even less than that for other people. Help people understand, please, that difference between inventorship on a patent, assignation, terms, or any other pieces I'm just not foolish enough, I'm foolish enough not to be able to describe.
Okay, so the first thing is inventorship, and inventorship is a person who mentally conceived of a feature in a claim. Mary alluded to that earlier. And then ownership devolves from inventorship. So if you are an academic, you normally have a contract with the university by which you have previously assigned your rights. Graduate students do typically as well. For corporations, you also have agreements when you first start, and what they're paying you, what we call consideration, is continued employment. And so the dollar that you got, Judy, didn't buy you much, but it was that continued employment that they consider as the payment for the invention. And so mostly ownership devolves from inventorship, but then it can be changed by contract or hired to invent.
Okay, so that's invention. Now,
yes.
That means that once I've invented, so for example, if I've invented something and I'm an academic, who is assigned that patent? Is the patent assigned to me as the inventor, or is it assigned to the university? Who actually then owns that patent?
Okay, so first thing, a patent should be considered as a piece of property. It can be considered a house, a car, it's the same thing. And the owner of that is, again, typically the university by contract. So the professor who starts invents something, but they have a prior agreement that the ownership of the property, the intellectual property in this case, is the university or the corporation. If they're out on their own and they're the inventor, then they are the owner and there's no assignment. An assignment basically is a sale or a confirmation of ownership by the inventor to a third party such as the university or a corporation.
And the third part of that then, terms, is, as you mentioned before, so the terms for my assignation to my company was $1 a dinner and continued employment. So, and the terms then are really the important piece here. So in the end, if I, as a university researcher, invented something and the university owns the patent, I can work with the university to get that patent back assigned to me, but it also has a set of terms associated with that, and those terms could be between the university and me, or if the patent is transferred to a third party, a company, that between the university and that third company, that is the terms. Do I have that right?
That's correct. You are correct. Most of the universities, including Oregon State, for example, do not assign their patents. They don't sell their patents back to the professors. That's a very rare event, and sometimes it's statutorily precluded. What they do often do is give a license back. I own it, but you can use it. So I will grant you a license to use, and it can be an exclusive license. Only you can use it, or it can be a non-exclusive license. I'm going to let you use it, but I'm also going to let Joe and Jill and John and everybody else who wants to use it as well. So I still retain, the university, still retain ownership, but I'm giving back to you at sometimes the right to practice under a license.
Very important point. And I've got to go over to you, Mary. Is that happen in every university, or do different universities? I know that in the state of Mississippi, for example, where I had an appointment, under the Murad Act, I could petition to have this assigned back to me or whatever. Is this the same in every state or every university, or how does that work?
I believe pretty much so. So the first part, to clarify what Stacy said about licensing back to the inventors, is what we typically do with startup companies, because usually the inventors are the founders of the startup companies. So we license that IP that they created back to them to use in their companies. Other times, and occasionally we do this, probably more often now, we will waive back ownership back to the inventor if we can. But we can only do that if we're absolutely sure that there's actually going to be no commercial possibility for that invention to go forward and find a licensee. And more importantly, make sure there is no federal funding, because on the statutory requirement, if the university we take title initially of the invention, but if we decide to waive it, we have to give the federal government the option to take a license to it or to take title to the invention first.
Oh, so, interesting.
So it's and it happens, and it has been done before. It takes a while and a lot of paperwork, but it's possible. But it's much harder to waive back the ownership when there's federal funding.
Got it. So people need to think about that a little bit then. If you're starting companies, you want to take your technology back, don't be afraid to approach your tech transfer office. Don't be afraid to say that they're going to say no. They want this commercialized. And if they do believe you're the strongest person to do that, that's probably a pretty reasonable way to do it. Stacy, I'm going to go back to you for a broad-based set of questions that I think would be helpful for some people. I'm seeing 2 or 3 questions along this line, and that is, could you help people sort of understand if they've invented something and they've done a disclosure or they've done a provisional patent and there's a certain number of inventors and then suddenly new students come in the lab or other collaborators come in and then suddenly new ideas come in. Are these people inventors as well? And then how do they have a right to inventorship, and then how is that negotiated, and does it need to be negotiated? Could you help clarify some of those pieces?
Sure. The first issue, patents, inventors are determined legally by the claims of a patent application or an issued patent, not by the disclosure. So there's a first part of an application that describes how an invention is made and used. And then there are numbered paragraphs at the end that define very specific aspects. So an inventor, for example, we have a claim 1. An inventor is any person who mentally contributed to the features of that claim 1. As the technology evolves, another graduate student might come in, and he or she might have contributed a feature. Now, if that feature is disclosed in the application but not recited in a claim, that person is not an inventor. It's a flexible concept. If then we add a claim to the feature that the new graduate student added, he or she then becomes an inventor. And so invention is a flexible term in the patent law, and that solely derives from the claims of the patent or the patent application, not the subject matter actually disclosed.
Gotcha. That's really an important point then. So people have to understand it's all about the claims. It's not just adding people in the end. They could add people in the end, but if those people were not really involved in what becomes claimed in the patent, then they are not inventors. Great. I have a question about the idea of the question of influence. So I'm going to go back to you, Mary, and this is I'm winding down to the last 2 questions so as quickly as we can do this because I still have other questions I haven't been able to get to. So I will apologize to our amazing audience who have given great questions, but we don't always have all the time left to do this. When a graduate student or a professor are listed on a patent, they're inventors. Can they actually influence, and what role do they have in influencing how that patent and how that technology is made available by the university to other parties? What's their role in that process?
We listen to the inventors, what they believe would be a good application. It's a discussion, negotiation. To understand. It's very important for us going through patent prosecution, especially the time commitments that it takes, that we have inventors who are willing to continue championing their invention. So it comes up for us where we'll have an invention which could be a great, there's a licensee out there, we might be looking to license it exclusively, but the faculty is looking to start up a company instead. Yep. It engenders a good discussion because, if you're going to start up a company using that invention, that intellectual property, you need to explain to us really quite what you're going to do with it, how you're going to set your company up.
Yep.
So, and that gets a dialogue going. Especially for startups, we bring in people that we know that can actually help faculty and the students start companies, and what they need to do.
So they can be part of the process, but you're really the ones who govern it, kind of in the end. I got a few more questions I'm going to try to move through quickly here. When you talk about this whole idea, Stacy, about claims, so what happens? You get the claims, and how many 3 of the claims are then not allowed on the patent? Does that mean that if those 3 claims were associated with one of the inventors and that a person was primarily associated with those claims, that person's not the inventor anymore?
That's correct. So we have to update inventorship at 2 points: when you file an application and when you issue an application. And so inventorship can change during the process. If Jill is an inventor of Claim 2, and for some reason we have to cancel Claim 2, and Jill's only an inventor on Claim 2, at the end of when the patent issues, Jill is no longer named as an inventor on that patent.
Very interesting. That's actually a couple of questions I've been getting from some people here. I'm going to ask my final question, the general question, to Mary, and then what I'm going to do is allow each of our speakers to summarize for a minute or two, and then we're almost done. So thank you all, but stay tuned for the free advice. It really, really matters. So Mary, what's the financial benefit to inventors? I mean, why would they bother doing all this? What's the financial benefit to inventors from a university license patent?
So I think all U.S. universities have more or less the same policy. We all royalty share back to the inventors department. Sometimes the different universities have slightly different setups, but Oregon State, just over 1/3 of any revenue we make from royalty or licensing goes back to the inventors. About 1/3 that also goes back to their department to be used however they choose to use it. And the other 1/3 we actually maintain for our patent budget within our office and to keep us self-sustaining. So there is a good revenue source for the innovations that we successfully license. I've got a number of faculty who are very happy, and students who 4 times a year open their mailbox to find a check in there that they weren't expecting. Sometimes they're big checks. Sometimes, it might be a few hundred, a few $1,000s. But it can pay off. It's also not only the financial element too, but I think it's the satisfaction of actually also seeing something out on the shelves or out somewhere that is being used that you played a role in.
No, you're right.
That's out there.
Okay, I'm just going to keep moving along here if you don't mind. Stacy, if you don't mind, give me just your big summary for about a minute, and then Mary, I'm going to ask you to do about a minute because I want to take us on track with closing down at 2 o'clock. So Stacy, what do you say? What is your big words of advice?
Well, first off, I think inventors need to be aware that their own activities can create their own priority against them, and they need to know what they are doing has ramifications for the patent process. So that's especially going to be true when you go first to invent. You also ought to be aware of the priority of the others. I'm continually amazed that people don't go to the PTO for the resources that the patent office has. So go to the patent office, check out the prior art, and be aware of the prior art. Mary suggested a thing I think is very important to us, and that is the inventors need to actively participate in the process. We have much better luck when the inventors are engaged and read the prior art and are available to us to help the drafting process. Always go to the tech transfer office. Mary and others at the tech transfer office are there to give you help, and they're very knowledgeable of what you do. Final piece of advice is patience. It takes a long time to get a patent application through the process. It can be years, and so don't give up. And then finally, a little plug: if you ever need any assistance, please shoot me an email at stacy.slater@clarkwest.com. We'll be happy to answer any questions we can.
And you work for people outside of the state of Oregon because we have listeners from all over the country. Is that a fact?
Absolutely, all over the world, not just the country, all over the world.
Okay, that's the last piece we're going to let you do as a free advertisement. Mary, could you please give us your final words of wisdom?
Well, I'm not going to recap everything that was said, but my wisdom would be don't allow your imagination to be clouded by your own prejudice. And I say that because from my own experience, how I got into tech transfer was in my graduate work. I worked on a novel cancer drug. It was a new drug for use in photodynamic therapy. And this was in England. And the prejudice in the lab was that tech transfer was evil, they stole your money, they took control, they were bad, terrible people, and you didn't want to have anything to do with them. And we published, and then as soon as we published, a whole series of pharmaceutical companies came by the lab wanting to fund research, be more involved. And as soon as they asked the question, you know, are any patent applications filed? And the answer was no, why would we do that? They just turned around and walked out the door. This means actually, you know, 20 years later, this drug never got off anywhere other than the research lab bench. No pharmaceutical company is ever going to invest in the research and development and translational costs it's going to take to make that a drug that is used that would actually have been much better if there were no horrible side effects, it's a long road, than what's actually currently being used. So it's, you know, don't let your prejudices cloud your imagination of what can be achieved. I think.
And make sure that you protect and ask the questions up front so that you don't accidentally do something that you couldn't. You can't go back. You can't a statement made can never be put back upon.
That's right. So be open-minded. So when we're here to help, any questions? I even field questions when you don't know what your question is.
And those are sometimes the best. So the bottom line is we are Tech Transfer, and we really are here to help you. So that's it, along with the attorneys who are here to help you. I apologize for rushing the questions at the end. I was just trying to do my best to get as many questions in as possible. I would like to thank our wonderful speakers and our terrific audience for joining us. If you'd like to learn more about the upcoming webinars, please remember to go to those two websites. And if you want to listen to or watch this webinar again with the slides, please do join us at the URL shown below, and we would love to speak with you. Last but not least, we'll be putting up some information. We did have some questions on what are sort of resources for prior art. Stacy did bring some of those up. Go to the U.S. Patent Office, and there's a number of other things that we can put together for you, and we will put those together because, as Mary said, the more informed you are, the more you can help them. They're wise, but they may not have every answer. Thank you all so very much for joining us, and look forward to seeing you at an upcoming webinar. Please check back. Hope you had a great time, and please have a great day. Bye-bye.